I'm joined now by one of the people who brought this issue to the forefront of the nation's public consciousness and who has helped us understand the nuances of the case, the esteemed former federal judge, J. Michael Luttig. Judge Luttig, again, thank you for being here. You and I have talked a couple times this week, but it's not enough because there's so much to this important case, this important 68-page ruling that I wanted to talk to you again. So again, thank you for being with us. Let's start with the Colorado Supreme Court disagreeing with the lower court in Colorado on one key point, that the president is an officer of the United States. On the other hand, both courts agreed that January 6th was an insurrection, that Donald Trump engaged in it. Colorado Supreme Court addressed that issue in the ruling by writing, although we acknowledge that these definitions vary and some are arguably broader than others, for purposes of deciding this case, we need not adopt a single all-encompassing definition of the word insurrection. Rather, it suffices for us to conclude that any definition of insurrection for purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. End quote. Judge, you believe this will be the crux of the case if it reaches the Supreme Court?
I do, Ali, and thank you for having me on this morning. The Colorado Supreme Court's decision is historic in its own right, regardless what the Supreme Court of the United States does with respect to the 14th Amendment question. It remains to be seen whether the Supreme Court will take up this particular case, but it certainly might. As you say, there are two essential critical issues to an interpretation of the 14th Amendment disqualification clause that the Colorado Supreme Court resoundingly decided. It was a masterful opinion of constitutional interpretation of the disqualification clause in the 14th Amendment to the United States Constitution in every single respect. It is unassailable as a matter of constitutional law. As you noted, the Colorado Supreme Court reversed the lower court's decision that Section 3 does not apply to the office of the president. The lower court had held that it did not, even though the lower court, as you noted, had held that the former president engaged in an insurrection or rebellion against the Constitution of the United States. The Colorado Supreme Court, in what is an unassailable holding and interpretation of Section 3, held in essence that the presidency is an office under the United States, one. Two, that the president is an officer of the United States. And three, that when the president takes the constitutionally prescribed oath of office, he takes an oath to support the Constitution of the United States within the meaning of the 14th Amendment. This is not only just the plain and understandable interpretation, it is grounded in the history of the clause and the history of the debates and the ratification history of the 14th Amendment. It would be impossible for the Supreme Court to hold under the existing law that the president does not hold an office under the United States, Ali. Then turning to the insurrection holding, pivotal to that decision by the Colorado Supreme Court is the definition that you read to your viewers this morning. The Colorado Supreme Court canvassed all of the possible definitions of insurrection or rebellion from the time of the framing and ratification of the 14th Amendment. And there were a number of possible definitions. The Colorado Supreme Court wisely chose the narrowest possible of those definitions and said it need not go broader, because that narrowest interpretation of insurrection or rebellion would extend to the former president's conduct before, on, and after January 6th.
I don't know how you remember to answer my two questions. I hardly remember that I asked two questions. Your brain is amazing, Judge. Let me ask you about a point that some have made, that disqualifying a GOP frontrunner is anti-democratic, even if it's legally sound. I want to quote from the New York Times, where they wrote, "The Colorado Supreme Court's ruling that Donald J. Trump is constitutionally ineligible to run for president again pits one fundamental value against another, giving voters in a democracy the right to pick their leaders versus ensuring that no one is above the law. Mr. Trump's status as the Republican frontrunner for the presidential nomination, despite his role in the events that culminated in the attacks on the Capitol on January 6, 2021, has created severe tensions between those two principles. If the court's legal reasoning is correct, obeying the rule of law produces an anti-democratic result," end quote. You have pushed back on this idea on social media. You think that's not a valid interpretation of what's going on here?
I do not. And the passage from the New York Times story that you just read is just fundamentally wrong. It seems to me that no sooner than had the Colorado Supreme Court ruled, than the politicians, but also, surprisingly to me and disappointingly, the national media took up the cause of not enforcing the 14th Amendment against the former president, notwithstanding its clear application to the former president because of his conduct around January 6th. That's misleading. And yesterday I tweeted, or whatever one does these days on former Twitter, to address this point, because it is of surpassing importance to the resolution of the 14th Amendment question. And I said in that tweet that it is the Constitution itself, Ali, that tells us that disqualification is not anti-democratic. Indeed, the Constitution tells us that it is the conduct that can give rise to disqualification, namely an insurrection or rebellion. That is anti-democratic. To me, that's about as clear as any document or constitution could make that point. I will say that instinctively, but instinctively only, it is a natural and expected reaction by all Americans, frankly. I would have hoped not by the national media, but by all Americans who are less informed and knowledgeable about our Constitution than the media is supposed to be. But upon thinking about it seriously, I think it's crystal clear, and it will be crystal clear to the American public, that it's the Constitution of the United States that's disqualifying the former president from higher office if he is to be disqualified. To speak to the political warriors, it's not President Joe Biden, it's not the Democrats, it's not the anti-Trumpers. It's the Constitution of the United States. And that's why I've said over the past week that this case tests America's commitment to its own democracy, the Constitution, and the rule of law. Section 3 of the 14th Amendment allows for, and according to the Colorado Supreme Court, requires the disqualification of the president. If he's disqualified, that is the constitutional answer and the law of the land, Allie.
Judge, I want to ask you about an article that was written in The Atlantic by Adam Serwer the other day. It's entitled, "The Colorado Ruling Calls the Originalists Bluff." And it says, there are a lot of practical reasons for opposing Donald Trump's disqualification. One is that it removes the choice of rejecting Trump from the electorate, which might seem undemocratic, even if done with constitutional provisions adopted by the people's chosen representatives. Another is that it could damage the legitimacy of democracy itself by appearing to confirm Trump's allegations that the political system is rigged against him. These are all compelling reasons to avoid or disregard this provision, notwithstanding its plain meaning and intent. A second rejection of Trump at the ballot box seems like the least destabilizing outcome. The problem for a majority of the justices on the Supreme Court is that they're not supposed to care about any of this, to a point that you were just making. They're originalists, remember? You've made the similar argument that based on the plain language of this clause, Donald Trump, by engaging in insurrection, simply doesn't meet this qualification to hold public office again. This is tricky, right? If you're an originalist on the Supreme Court and you say this is what the thing says, then you can't be bothered by the noise outside.
That's true, Allie. I haven't had the opportunity to read Adam's piece, but based on what you said, I would say this, reiterating in part what I've said earlier. This is not politics. This is the Constitution of the United States, and it poses for the Supreme Court of the United States a pure question of constitutional law. The Supreme Court of the United States is never to consider extrajudicial factors or considerations such as partisan politics or even politics writ large. Let alone is it supposed to consider things like have been reported recently in the major media and not reported, urged by the national media, that rather than interpret the Constitution as it's written, the Supreme Court should instead fashion an opinion of statecraft, which is shorthand to those of us in the law, to fashion a result under the Constitution other than the one compelled by the Constitution, Allie.
Judge, I appreciate that you are leaning into helping those of us who are not experts on the Constitution or the law, particularly those of us in the media, to understand this so that we don't sort of circulate the wrong message out there in our soapbox interpretations of these things. We always appreciate your time. I want to remind our audience that you and Lawrence Tribe were on with us on August 19th when you first popularized this idea. You both gave credit to other people who had done some of the work, but you came out here, you wrote an article in The Atlantic, and then you came on here to talk about it, and we appreciate you and your continued service.